Do you know your rights as a tenant during an eviction? Understanding evictions is the first step to knowing your rights. But what exactly is an eviction? In simple terms, an eviction is a legal process through which a landlord can remove a tenant from a rental property. The reasons for eviction can vary. It might be due to a violation of the lease agreement, such as not paying rent on time, causing significant damage to the property, or engaging in illegal activities on the premises. However, eviction isn't a simple "you're out" situation. There are laws and procedures put in place to protect tenants. These laws vary from place to place, but they generally aim to ensure that both landlords and tenants are treated fairly in the process. Now you might wonder, what rights do I have as a tenant during an eviction? Well, the answer to this question is quite extensive. For starters, you have the right to receive notice about the eviction. This means your landlord can't just show up one day and order you to leave. They are required to provide you with a written notice, giving you time to rectify the situation or find a new place to live. Furthermore, you also have the right to respond to an eviction notice. You can challenge the eviction if you believe it's unjust. If the dispute can't be resolved amicably, then it may proceed to court. And yes, you guessed it, you have the right to a court hearing. Another important right to note is your protection against self-help evictions. This means your landlord cannot take matters into their own hands by changing locks, removing your belongings, or turning off utilities to force you out. So there you have it, a brief overview of what eviction is and a preview of the rights you have as a tenant. But don't worry, we're just scratching the surface here. Stay tuned as we delve into the specific rights you have as a tenant facing eviction. How much time should you be given before an eviction notice takes effect? That's the question we're tackling in this segment. When we talk about eviction, one of the first things that come to mind is the dreaded eviction notice. But did you know that as a tenant, you have the right to receive this notice in writing? Yes, you heard it right. This is a fundamental right that you have, and it's there to ensure that you're not caught off guard by a sudden eviction. Now, on to the next important thing, the notice time frame. This varies quite a bit depending on where you live and the reason for your eviction. However, in most cases, you should be given at least 30 days notice before an eviction can take place. In some situations, such as if you've been a long-term tenant or if there's a breach of contract involved, you might even have the right to a 60 or 90-day notice period. The key is that this time frame should be clearly stated in the written notice you receive. But why is this so important? Well, this notice period gives you the time to either remedy the situation that led to the eviction notice or find a new place to live. It's not meant to be a period of dread, but rather a buffer to help you prepare for what's next. Remember, landlords can't just wake up one day and decide to evict you without proper notice. They must follow the proper legal procedures, and this includes giving you a fair warning in the form of a written eviction notice. So before any eviction, you must receive a written notice. But what can you do once you receive this notice? That's what we'll be exploring in our next segment. So stay tuned. What can you do once you receive an eviction notice? It can be a jarring experience, to say the least. But remember, you have options, and one of the most important rights as a tenant is the right to respond. So let's delve into this. When you receive an eviction notice, it's not an immediate order for you to leave your home. Rather, it's a legal document that starts a process, and this process allows you to respond. You have the right to challenge the eviction in court, negotiate with your landlord, or choose to move out by the notice deadline. So how do you challenge an eviction in court? This process often starts by submitting a written answer to the court within a certain amount of time after receiving the eviction notice, usually between 5 to 30 days. In your response, you can provide your reasons for challenging the eviction. Maybe you believe the eviction is not justified, or perhaps there's a mistake in the eviction notice. Whatever your reasons, make sure they are clear and concise. Negotiating with your landlord is another option. This can involve discussing the issues that led to the eviction notice and finding ways to address them. Maybe you can agree on a payment plan for overdue rent or commit to resolving a lease violation. Remember, it's in both parties' interest to avoid a time-consuming and often costly eviction process. So, engaging in open and honest dialogue can sometimes lead to a resolution. Finally, you might choose to move out by the notice deadline. This option is often considered if the reasons for eviction are clear and undeniable, and you've decided not to challenge it in court. By leaving voluntarily, you can avoid having an eviction on your record, which can make finding future housing easier. So, you see, you're not powerless when you receive an eviction notice. You have the right to respond, and how you choose to do so can greatly impact the outcome. After responding to the eviction notice, what happens next? Let's find out. Is a court hearing mandatory in eviction cases? You might be surprised to learn that the answer is an unequivocal yes. Let's delve into the intricacies of the tenant's right to a court hearing. Now, eviction can be a daunting prospect. It's not just about losing a roof over your head, it's about the uncertainty, the upheaval, and the stress. But here's an important thing to remember. Tenants cannot be evicted without a court order. That's right, it's not just a matter of your landlord deciding one day that they want you out. They must go through the legal process, and a key part of that process is a court hearing. So what does this mean for you? In essence, it means you have the right to present your case before a judge. This isn't just a token gesture, it's a fundamental part of the legal process designed to protect the rights of the tenant. It's your chance to explain your side of the story, to present any evidence you might have, and to challenge any assertions made by your landlord. The court isn't just there to rubber stamp the landlord's decision, it's there to ensure that justice is served. Now, this doesn't mean that the court will always rule in your favor, but it does mean that you'll have the opportunity to make your case. It's not a guarantee of success, but it's a chance to fight for your rights, a chance to make your voice heard. So, if you're facing eviction, don't be disheartened. Remember, you have rights, and one of the most important of these is the right to a court hearing. It's not just about the law, it's about fairness, it's about justice, and it's about your right to be heard. Remember, a court hearing is your opportunity to present your case. But what if the court rules in favor of your landlord? Can your landlord force you out without a court order? This is a question that plays on the minds of many tenants, especially those facing the prospect of eviction. Let's delve into this. The answer is a resounding no. As a tenant, you have the right to avoid what are known as self-help evictions. Simply put, a self-help eviction is when a landlord takes matters into their own hands to oust a tenant without going through the proper legal channels. This could take the form of changing locks on the property, turning off utilities like water and electricity, or even removing the tenant's belongings from the premises. It's crucial to understand that these actions are not just unkind, they're unlawful. Landlords are required by law to follow a specific process if they wish to evict a tenant, and this process does not include any form of self-help eviction. So, if you find yourself in a situation where you're being forcibly removed from your home without a court order, remember this: you have rights. Now, this doesn't mean that every incident of a landlord changing locks or turning off utilities constitutes a self-help eviction. There may be legitimate reasons for such actions, such as emergency repairs. However, if these actions are being used as a means to force you out of your home, that's a different story altogether. So, what can you do if you're facing a self-help eviction? Firstly, don't panic. Stay informed about your rights and consult with a legal professional. They can provide guidance on your next steps and ensure that your rights are respected. To sum up, remember your rights: the right to notice, the right to respond, the right to a court hearing, and the right to avoid self-help evictions. Knowing your rights is the first step to protecting yourself during an eviction.